Another popular records retention myth relates to the exact length of retention periods. In many businesses, regardless of size and sector, there is an assumption that all records should be retained for exactly 7 years. This assumption is applied much too widely. There are some laws which specify 7-year retention periods, but there are many more laws and sections of laws which specify other retention periods. Some are shorter than 7 years, and some are longer. Which requirements apply will depend on where your business operates, what it does, and what specific regulations govern its activity. For example, even though accounting records are commonly retained for 6 or 7 years, there are some specific taxes that can be reassessed within 10 years, and some governments are legally authorized to investigate alleged tax fraud at any time without limitation. Maybe your organization needs to keep accountings for a longer period of time in order to help manage these legal risks. Nor is records retention as simple as counting years. Some legally mandated retention requirements specify an event that must take place before the file is closed and a retention period begins. Even if the law prescribed a retention period of just 2 years, the actual record might sit around for years before that 2-year clock starts ticking. If records retention periods are so specific and complicated, then how do we begin to apply them to real records? The short answer is carefully and proactively. The first step is to create a system for organizing records into categories. These categories support information retrieval and provide the basis for making decisions about how long to keep the records. How exactly do we categorize records? Industry standards prescribe classifying records according to the business functions or activities that they support. The functional approach makes sense, both practically and legally. We need information to support our business activities, and we might need recorded evidence to defend our activities in a lawsuit, audit, or other sensitive situation. So let's retrieve, retain, and dispose of records according to the same activities. Once the categories are defined, research the different statutes, regulations, and operational needs associated with each activity. Do laws spell out requirements to retain certain records for a given number of years? Are there any legal limitation periods that define how long records would be relevant for litigation or audit purposes? And when exactly do all those time periods begin? This ends Part 2 of 4 of Records Retention in the Real World.